Welcome to the Atomic Level, the show where we decode the matters of wealth, one insightful conversation at a time. And on Wednesdays at 10 a.m. Pacific, 1 p.m. Eastern, where we decode your questions related to Shields and Succession with Matt Miley for Matt Chats, our open office hours, and our AMA related to all things estate planning, legacy planning, asset protection. If you are new to the show or the podcast, you can check out prior episodes. We cover your questions against our articles, and we try and bring them to life with Matt Miley and other attorneys from the firm like him. Now, Matt is an attorney. He is not currently probably your attorney. He could be, but he's not yet. So none of this today should be perceived as legal advice. However, it is important to understand and think about, maybe discuss with your attorney. If you are looking for representation and you're a Colorado resident, you can call 970-820-0090. If you are in all other 50 states interested in asset protection and things like that, call the Wyoming office, 307-463-3600. And if you just want to listen and take this stuff to your counsel, we're happy to help you there. That's what these are for. Matt, welcome back to the show.
Thank you, Chris. It's good to be back.
It is. It is good to be back. I missed you last week. I was in a conference down in Scottsdale, Arizona, with about 2,500 people with somewhere north of $1 million in assets at the Limitless Conference. Shout out to Ken McElroy and Danielle and Tarl and the whole team over there. They put on a great show in 110-degree heat, and that was the coolest part of the whole deal. I mean, the actual show was really interesting. A lot of interesting concepts. One of the ones I wanted to talk with you about was this concept of legal litigation as an investment class, which is not something that's new, but that has surprisingly, and I didn't realize the growth rate of it, compounded at about a 9 to 11% compound annual growth as far as the amount of money, capital, that has been invested in funds that literally fund lawsuits against people, because it's apparently, good and big business, to the tune of about $16 billion worth of capital that's been organized as of 2025 anyway. I don't know what the number is this year, but at that growth rate, it's probably closer to 20 billion. And so whenever somebody puts their capital into an asset class, it's usually because it's returning better money than another asset class. And when capital is forming at a double-digit compound annual growth into an asset class like litigation funds, it kind of plays to something you've said before, where we went from like an empowerment society to kind of like an enablement society to, I think you called it an envy society. When we see these things happen, it's likely that people with decent means are more likely probabilistically to be party to a claim or a suit that they didn't see coming. And the math seems to say that more of that's on its way. So that's what I wanted to talk with you about today, Matt, and help people get prepared for it.
Okay. Well, yeah, thanks, Chris. It's a good lead in. I'm glad you saw the conference. Yeah, I did mention that a few episodes ago, how when I was kids starting out, it kind of seemed like we were I call it the three E's, that we were the enablement society, or empowerment society, empowerment society, where when I was young, it just looked like if you played by the rules and did what you're supposed to, you you moved up in the world. You got to start accumulating assets and things like that. And then all of a sudden, as I was working a little later in there, it seemed like we shifted to the second E, which was the entitlement society, where it was just like people were thinking, just because I had a degree, that means I don't have to work at the factory anymore. I should just get paid like the owner, that kind of thing. You just owe me. You just owe me because I have what I've achieved what it has. So I'm just owed now. I don't have to put any sweat equity into the deal. And then now it seems more like you were talking about, is that envy society, that if you have it and I don't, and I want it, well, maybe I don't want it. I just don't want you to have it. So I'm going to come up with laws and find out ways to take it away from you. And, I'm thinking during that time, we've always said that if you have no assets, you're kind of judgment proof. What does that mean? Well, that means you can get a judgment against you, but how did you collect? I mean, if you don't have anything, there's nothing to collect. We talk a lot about that with some folks when they had their own personal residence. If you have a personal residence with a reverse mortgage or a huge mortgage on it and things like that, a lot of people aren't going to go after that personal residence because they have to pay off the bank before they get the money from suing you. So that kind of makes you a little more judgment proof as well. But as you don't have the judgment proof, as you gain more and get more, it seems like the bullseye on your chest gets a little bigger and bigger. And now you get more exciting to other people to take that away. And I think that's what we're seeing happening here is that you have this money, you get this big visibility. These funds are attracting more money because there's ways to go after certain segments of the society and make a lot. When I look at the billboard driving around on our interstates here, I always see, I used to see, hey, call this person if you're in a car accident. Well, now it's truck accidents, and it's like, and not only any kind of truck, it's got to be like a government owned truck or a big company owned truck. We don't want to hear about pickups and all those kind of things. So, now it's just like, unless you're hit by a truck that some company owns, don't call us. It kind of seems like so everyone's getting their own niche where it seems like they get the biggest bangs to the buck, and they have certain ways to take that money away, and certain we call them nuclear awards by the jury. Certain ways to talk the jury into giving amounts of money. So I totally believe that that is happening. I've seen it in my life. I've seen it. With other people that we represent. And it all comes down to there is now a need as more and more of us have things. It used to be a big thing to become a millionaire in this country. Now, if you don't have a billion, you're not much. So it seems as the stakes are going up, it seems like the protection that's needed is more and more needed as well because we now have teams of made for TV attorneys that are ready to take that away from you. And they've done it before. They know how to do it. So, if you have an
Well,
LLC,
now and yeah, now they're well funded, meaning if they are a good team and they have a way to do that and they have a case, there are investment funds that have organized over the last 10 years since 2016. It started out around 6 billion under management. Now it's over 17 billion under management. So in the last 10 years, there's been this kind of underlying capital structure that also creates this war chest or this dry powder for those kind of actions to be profitable, to be taken. And again, it's probably why it's no longer about the guy's pickup truck that you're going to go sue for your damages around getting your bumper fixed. It's now like, let's go after whoever has, the best reason to go after, right? Who can we go get the settlement from, or who can we go win a judgment against?
and
As
it
a
doesn't seem
small,
like insurance
small,
either. Doesn't seem
you
like
know,
just
here,
either. You're going after more than but what you're insured for. So I mean, that's why you went after the small pickups and those things in the old days because usually the insurance was big enough to make you go away, and you were almost you had to sue somebody because if you didn't, it was so easy to pick up that insurance money. But now the awards are going way beyond the insurance limits, so it's just going after those assets.
so before we get into the audience questions here very shortly, just for one more piece of context, um, fans of the show know that I had Charlie Garcia back on for a second time about a week and a half ago. He wrote an article this week called "Free Everything is Coming for Your Money. Here's what to do before 2028." I encourage people to check it out if you're on Substack. I love this line because normally Mondays are gated with Charlie, and he said Mondays are gated, but today the whole thing is open because charging admission to an article about socialism felt like entrapment. He's got a sense of humor like you, so I appreciate that about Charlie. But the stat that jumped out of me there was uh, that essentially Cato Institute has an estimate that there are roughly somewhere in the neighborhood of 71 to like $220 trillion worth of democratic social whatever it is, DSA. I don't even know what that stands for, but the party that's kind of like taking all the noise now, right? With all the young guys and Bandami and all that. So the the DSA has somewhere between 71 trillion and 229 trillion dollars worth of proposals that essentially the government's going to fund so that you can have everything free, and they're going to tax the rich billionaire class their fair share, right? So that whole story. And again, I'm not getting into the politics of it, I'm getting into the math of it. The thing that jumped out at me was Cato Institute had this number of what's like on the table. In other words, we're promising all these free things and they're going to cost what? Well, they're going to cost somewhere between 70 to 200 trillion. And if you added up all the wealth of the Forbes 400 or whatever, the richest people on the planet, it comes up to 8.5 trillion. So even if you took everything from from everybody who's in the quote unquote class that needs to pay the fair share, you're not even at 11% of the lowest range of the total proposals that they're pushing down people's throats as things that they want. Now, what's the point? The point is, I don't want to get in the argument over it. It's not about the argument. It's about what you can do about it. Because arguing about it isn't a strategy. It just makes us angry. It doesn't do anything. It's like a rocking chair, right? It gives you something to do, but doesn't get you anywhere. So that's not what we're here to do. What we're here to do is practically go for a, $1.5, $2 million net worth family that's, pretty low key, done what they did right, been stewards of their money, accumulated some level of wealth up to the, family office or up to the 30, 40, 50, $100 million family. Those families probably have some plans in place. Hopefully they do. But when it comes to asset protection specifically, they may have gaps and there may be vectors of attack that they didn't think about because, again, they wouldn't do it to somebody, right? The simple way is I did what I did because I want my kids or this to have it. I want to pay whatever minimum taxes I can based on the laws and incentives I've given. But they're not thinking about getting attacked every day, and they shouldn't. That's not no way to live. But when you have the kind of movement that's happening, one of the other standout lines in it was a fraud can be unwound, but a majority cannot. And I thought that was a really powerful statement that Charlie made because you can call these policies and this thing a fraud, but the reality is it's not. It's a majority. And whether we agree with what that majority's consciousness is currently thinking or how they were educated or what they understand or don't isn't the point. It's the point that you can't unwind a majority easily, but you can prepare for what that majority might cause to have happen in your reality. And that's what we're here to try and help you think about and take action on. So with that context, I just want to get into some people's questions that came in. So one was, I own a profitable operating company, some real estate, brokerage accounts, and a little bit of crypto. What's the first thing I should inventory, Matt, before I even start thinking about LLCs, trusts, or other asset protection structures?
So the question is asking what personal things they need to
Yeah, like
inventory.
what's inventory? How do they assess um, the stuff they have before they figure out where it should live, what containers, what architecture, or should they start with the architecture? I guess I'll add to that question in case it helps you go one way or the other. But that was the question that came in.
Well, yeah, the main thing is just try to get a valuation for all those things, and that's what's tough. A lot of those asset classes that you mentioned, you just can't really hop on the internet and find out a fair market value for those things. Businesses, small businesses, closely held companies are really hard to value and things like that. So that would probably be the first thing is come up with some ideas on how to find out, how much do you have? Because a lot of times in asset protection, the first line of defense is insurance, and knowing how much you need to insure, that's pretty much a good start to protecting yourself. Again, someone else pays the claim, but that is one of the things that would need to happen is kind of find out the value there. But maybe even before you did that, if you took a step back, you would kind of think, what lifestyle am I leading? Is it a risky one? Does it tend to be out there showy and make people want to come after me where everyone can see the bullseye on my chest? Or are my assets more private than that? Am I, naming them on Facebook, hey, you should see my cryptocurrency collection and my wallet. how risky are your activities? Because if you're under the radar and no one can find you, it's great. There's a lot lower hanging fruit to go sue rather than you.
That it's an interesting question. There's two parts I want to follow up with that. So, we live in the era of influence. Celebrities have always been a thing for the last 100 years, especially since the television kind of was invented. We've kind of created a celebrity market, but now that kind of pairs out. You could be a Division II college athlete or a Division I volleyball player, which is not televised, but you could have significant um, name, image, and likeness monetization, and so in other words, when you're a public figure of any scale, it's very hard to conceal, even if you're like super humble about it. In other words, like you could be a public figure talking about things, but not being flashy, not driving around a Rolls Royce, is not doing the 90s thing where you're wearing chains and you're doing that, or the 2000s thing where you're just spending $1 million on a party, or Desperate Housewives thing or whatever, where you're doing that on purpose, like where you literally are trying to basically stay somewhat below the radar, not draw attention to yourself, but your public personality is well known and documented. So therefore your target increases simply because you're out there. There's a different strategy for that person than there is someone who runs a $30 million a year, small business in a region, maybe has some trucks on the ground or some footprint retail and is known locally, but that doesn't exist in the public persona. Again, same thing though. If I think this business is thriving and I see a truck on the road and it gets into an accident, like all of a sudden that non-celebrity thing becomes a target. But are there nuances that are different? I mean, the obvious thing would be like, how does someone who is publicly famous for themselves, their name, you know, not own stuff? That's option one. Option two, if they do own stuff in the era of FinCEN disclosures and things like that, where you have to literally fill out a report of who the ultimate beneficiary is, where do some of these things even break down structurally that you and I deploy, or that you recommend deploying, like asset protection trust? Because at the end of the day, like if I go into court and I'm under deposition or I'm under the oath of law, I kind of have to say what I own, even if it's not easy to find. So how do I kind of prevent against those realities if I get put under duress, where I can be above the board, but I still can have that asset protection judgment proof nature?
Well, yeah, a lot of it just starts with, privacy and setting up the structures in such a way that no one doesn't really have your name on it. It has your company name, or it has your entity that owns it, but through ownership, you can maintain some privacy and to set those entities up in states that also honor that privacy. So the name's not out there on the Secretary of State's office where they say, "Oh, this person owns this and this." It starts there, but it even starts before that, and kind of how you react to your world. I'm a big football fan, and I watch all the YouTube videos on my teams and things like that. But when you think about a lot of those owners of those football teams, some of them we know about. Some of them are a lot more household names than others, and it's usually how public they're getting, how much in the operation they're getting out there, how much of the limelight are they seeking? Are they the ones doing all the press releases? Are they doing all of the speeches instead of the coach or those kind of things? So, they want the limelight, and so you know a lot more about those owners. You figure all of them have a lot of money because, I think the next franchise they're talking gonna be 6 to 10 billion, to own one of these things. So it's a lot of money. But if you think about it, a lot more of them are more popular or more in the public eye than others. So I think that, it starts there with, privacy may be a right, but it's also a responsibility. I mean, you just can't be doing, shouting out your name everywhere and being on social media time and then
Well,
complain privacy.
so I think one of the other things that you've talked about before, but I think might be relevant as a nuance here is who does the thing also dictates whether the thing is discoverable or not, if and when a claim ever arises. And why I want to bring that point up now is that let's just say you are publicly known at whatever scale you're publicly known. Doesn't matter. You could be a famous top 100 celebrity or a football owner, or you could just be the best sandwich shop in your town with 5 locations and everyone loves you and knows you, but then till they don't. The point is you're in business, you have customers, you have an impact, you're making money because of it. And so privacy is one thing, but protection is another. Obviously, if your business has a geographic footprint in a state that doesn't respect property rights or is moving down the path of less respect for property rights, well, then that's going to be a do I stay or do I go decision, because you can't really deal with the nexus of a thing like you can't move a physical location out of California and have it not be subject to California law just because you decide you're going to put the entity somewhere. But if you have options, like if you have a business where it can operate in any state or remotely, but you live in a state like California, for instance, like I do, well, then if you don't own anything, but you're on TV talking about stuff all day, then that's going to draw a red flag because people are going to know, well, wait a minute, he's private, but he's got to own something. And so there's this kind of balance of what do I own and structure so that I not only look good on paper, but it makes sense so that people go, oh, okay, well, that guy owns a business and here it is. And it says he does. And if they want to go after it, they could go after that business. But where if they go after that business, you could ultimately cascade a bunch of things and go, fine, here's the piece of paper. You now own it. But you didn't lose your IP because the IP and some of the other things that business needs to operate are held in a structure that's in a state where property and privacy and charging orders are really rock solid, whether it's Wyoming or what have you. I think that's the question that I have is when you set those things up, there's a way to do that right and wrong. And you've talked about what becomes discoverable or not. And I want to clarify that again for folks. Like, what should I do when I'm making a decision or doing something through my attorney versus ordering it myself? And how does that make that privacy become protection, not just privacy?
Yeah, so, yeah, what you're, mentioning is there are structures out there where you can ownership of certain things can be put in other states, especially if those are, like you say, virtual or they're movable cash, you can invest that in another state, those kind of things, and they can be owned by another other entity that, you may or may not have total control of, but the idea is they're no longer all yours, they're no longer under your brand, they're no longer under that state where you're doing business. Um, typically the assets in that state where you're doing your business, you need to have entities probably in that state because that's usually how they're looked at. But when it comes to an attorney, working with an attorney, a lot of the things that attorney does, he's client, and that's why it's important to have engagement letters, have an attorney on your site somewhere. Is those are confidential. Those discussions, those uh, work sessions, and things like those are confidentials. And then there's another closely related doctrine to that, which is called work product, where if it's done by an attorney, it's part of that work product. It's not necessarily confidential, but it's not discoverable because it was part of the work of the attorney doing it. And that's where it's important that if you are doing work and things like that, that it's asked for by your attorney. For example, if someone needs a balance sheet or a profit and loss statement from your accountant, well, if the attorney asks for it, it could still be maybe considered work product, still covered by client privilege, or the work product doctrine, better way to put that. But if you ask for it, it's not yours. I mean, it's
So for
yours.
it's I go for a practical reason, just to walk through the practicality of that. So if I do it wrong, what it might look like is I walk into a bank, I want to get a line of credit or I want to get a working capital line or something like that. I walk into a bank, I do a normal thing, go get a loan, right? And so they fill out an application. They say fill out an application and da 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 da. And I have to fill out either a personal financial statement and or a business balance sheet thing. If what I do is I fill that out and then I call my bookkeeper, accountant, whomever, and say, hey, I need an active balance sheet and I need it to be sent to so and so over at Bank XYZ, that is discoverable. But if what I do is I go, Matt, I need a balance sheet so I can go get this loan application completed. Can you call the bookkeeper and get me whatever I need so I can submit the application? If you do it, now whatever that balance sheet was that you requested is work product, which means if something ever happened and the creditor came, that would not be discoverable.
That's the idea. Yes, I still need to maintain that. Practical example is we have CPAs or banks all the time say, well, we need a complete copy of your trust for the account. You're trying to open a bank account in the name of trust. We need a complete copy of the trust. Well, when it's in your attorney's office, it's attorney-client privilege. The minute that's sent over to the CPA or to the bank, that's discoverable because they don't have an attorney-client privilege. They're not attorneys. So that's what you need to really be careful having.
So how do you navigate that? Is it more of a, well, I'm glad that you'd like to see it, but you don't need to see it, and you either don't open up an account there, or in other words, is there a way around it to still get what you need, or is it like the T's and C's that we sign away when we click on ChatGPT and they go, we can change these at any time, and by agreeing once, you've agreed forever unless you stop wanting to use the product. Like, is it a losing battle? I guess is what I'm trying to get at. Like, is this all just mental, you know, overthink for a world that's just being more confiscatory, or is there actually prudent ways to push back within the rights that are afforded to us and do this in a way where we can still get what we want, i.e. the bank account open or the crypto exchange thing open, but not give up the very nature of what we were trying to legally preserve for ourselves. Like, I just want to understand, even for myself, let alone the audience, like how realistic is any of this?
Well, currently, I mean, that's whatever the bank says they get typically because they may be the only bank in the region. And you have to use them, and so what they ask they get. But there are statutes out there that say that if you show them these 2 pages, it's enough, or if you show them this part of the trust, it's enough, so that they don't have the beneficiaries' names and all those other things, their birth dates, all those other things that we want to keep private. Are those part of the full trust? So first of all, it's the statute. Some states have a penalty, that they have to pay for all the copying or whatever in there that makes it's not very heavy handed. Not a lot you can do. But I'm imagining as this becomes more and more problem again. I talk about the 3Ds, and we're just getting into the third or fourth E at this point, and I think you're going to see um, or more of us, between the 2 to 30 million clients. I think you're going to start seeing the formation of some family offices and things like that, where there's a team built within that office, and the office can be quarterbacked by maybe the attorney, so that everything relates up, so that everyone's working for the attorney. So, you're not giving it to a third party; you're giving it to like employee of the attorney. And then with that, having 30, 40 families that you're shepherding through their cycle of passing their monetary wealth down to the next generation, they will work with certain banks. They will get these things set up for you because it really takes a village to get everybody on the same page. Right now, there's so many silos out there, Chris. Everyone's doing their own thing that they want to see the whole document because I want to make sure the attorney knows what they're doing or whatever. Vice
Yeah,
versa.
I think that's where you and I have a shared vision in where the world needs to go, where it also works for that, call it $2 to $30 million net worth family, end up obviously, but the financial desert is, and what I consider to be the most vulnerable are, the middle class millionaire, right? Like the millionaires that basically are rich enough to have a problem and be comfortable, but they're not rich enough to buy the protections afforded the billionaires, right? In historical terms, but now with the advent of intelligence being commoditized and things like that, as you know, I'm passionate about. The reality is now a virtual family office can function like a multifamily office used to for a fraction of the annualized cost. And Now you have to rethink your team because that typical 2 to $30 million net worth family that we love to serve has disparate advisors for things. Maybe they have an RIA or a broker dealer that does their money, right? But that person has never met their CPA. And maybe their CPA is, been multiple over the years. Maybe it's one, who knows? Maybe they use H&R Block still. Just it doesn't know. And then so the strategy is not there, right? And then they may or may not have an estate attorney. Probably what they did was they bought a trust or a will. If they did, if there's 77% of the people over 55, they know they need one. They haven't done it yet. So instead of looking at it like who's the quarterback or not having a quarterback at all, what you're suggesting, I tend to agree with it, is because of that work product doctrine and some of that stuff, you could make a very key argument that you should find a asset protection / estate planning attorney to kind of be your family business manager or your your chief family officer type of thing. And then either make all the other advisors that you keep kind of coordinate through that person, because it doesn't change your relationship with them, but it just keeps an architecture where your insurance, everybody else is kind of on the same page. And if and when things are ordered or distributed or banks are opened, the attorney has full line of sight into what could be discoverable, what not, before there's any duress.
Right.
And for a
Well,
$230 million net worth family, this is like not something most people have thought about because, again, attorneys have always been a billable hour. It's expensive. It's not a fun conversation. Every joke starts with a lawyer did what. And so it's like the last thing they would think of. It's almost like they'll go to the financial advisor, they'll go to someone else. But when you think about it through the lens of protecting it, not just growing it, the quarterback really has to be probably someone like yourself. That's Chris's opinion.
yeah, I mean, the protection is the key. If you're looking at asset protection, and you can protect $10 million, that means a lot more to someone who has between 2 or 30 million than it does to someone who has hundreds to billions. I mean, because it's everything. It's
Right.
everything. You should be thinking about asset even more for those folks. But it is the team, the coordination, putting it together, and just finding out from the team what's the major goals, right? Because everyone has a different goal. I mean, CPA has a different goal from the financial advisor. Um, financial advisor has different goal from the insurance advisor. All these things, the banker, everyone has different goals, and so you're creating all these independent documents that are trying to do different things. Asset protection, you get all these entities. Well, now you gotta do a tax return on those entities. You need to cost twice as much or 5 times as much at the accountant at the end of the year. Accountants go way over all these things because they are just filling out a return that has very little on it, and they're not filling the asset protection side. So I think it's getting everyone on the same page. And, it goes back to the reason we started this with getting everyone on the same page includes getting the parents to on the same page as the kids. So when this wealth is transferred over, everyone knows why they're doing things. That should be the office, the family office as well. Why are all these professionals getting together? What are they trying to, or who are they trying to serve, and what are they trying to protect?
So let me get back to some of the audience questions now because these are kind of nuanced, but I think they're pretty fast, quick answers, but relevant ones, right? So number two was, how do I know whether I have a genuine asset protection issue versus just the standard insurance and estate planning issue? And which one should I solve first of those three? So it sounds like, just help me understand the difference between an asset protection vulnerability versus an estate planning vulnerability or an insurance risk.
Okay, well, the estate planning side of it that has different risks than asset protection. I mean, there's a lot of things with when we talk about estate planning that we're concerned about besides someone taking all your assets as asset protection. But when you're looking at estate planning, we're looking at who's going to take care of you if you're incapacitated, who's going to make decisions the way you would make them should you not be able to make those decisions. We also talk about losing your property. What happens when you pass away? Does anybody know where all your property is? Do they know how to get into your crypto accounts? Those kind of things. We look at that lost property. Some people want to avoid court and probate. It's a different thing for court and probate. And a lot of people want to avoid estate tax, which are, is a completely different type of arena, and then we're talking about asset protection. Insurance, the insurance is a little closer to asset protection because insurance is like, oh, I got a policy that's going to cover up to this amount, and hopefully the plaintiff's attorney is going to take that instead of what I have, right? Hopefully they're not going to go over the limits or want more than the limits are and those kind of things, which is what you have to think about with insurance. Am I insured up to a high enough level where someone's like, oh, when I spend up the money, jump that and come after you get the rest of it? So that insurance is there as well. So based on everything you asked, estate planning is typically what we like to get in place first. We like to have the place for the money to go. We like to be under the threshold for taxation at the federal level. We want to be under the threshold for taxation. We also want someone to be able to pay for your skilled nursing facility, whatever, if you're incapacitated. And we want your kids to know where your stuff is, so things won't get lost. Um, Getting that set up is our foundational estate plan. That's what most people need. Then the next thing, because of the cost and ratio of trying to build an asset protection trust or all those kind of things. The next thing you probably need is the insurance, to get what you have, safeguard what you have. So first get it so that it's got a place to go and you got someone to make decisions for you, and then get it so you can, replace it if it's lost or safeguard your assets with insurance. And then as your portfolio grows and whatnot, that's when flat out asset protection starts becoming more of a thing. And now you're talking about keeping other people from taking it, where insurance is they're taking your insurance, they're getting something, they're just not taking your stuff. But they could if they wanted.
Yeah, and I have to have one of my insurance guys on one of these with us to talk through that. There's some interesting strategies I've seen older generations do with the skipped generation around insurance. For instance, there are ways where if whole life is part of your strategy related to your estate planning or your legacy planning, and you are the one with capital and you have a grandchild or a young child. So let's say you're in your late 60s or whatever, and you're starting to think about your inheritance, you're passing it down and that piece. Um, you can be the owner of an insurance policy, the beneficiary can be someone else. And so instead of you getting rated and whatever with, your smoker's cough and your high blood pressure and your diabetes, you get your 7-year-old grandchild, your 5-year-old grandchild, who's ultimately going to end up with your money anyway as the beneficiary. And then you fund the plan and you're the owner of it. So when it comes to the cash value or some of the things you might need to do, whether it's loans against it or whatever, you have that utility. And I might be getting this wrong. The insurance guys will correct me in the comments, but there's a strategy out there that I'm aware of where people are doing that, where they're funding the grandchild or whatever's life plan. They have access to the cash value if they need it to make it through some of their later years. So they get the benefit of the liquidity, but then their trust and everything has the instructions that says, look, upon my death or upon my incapacity, right, then the ownership of this will transfer to the beneficiary. So now that beneficiary that ultimately ends up with it at the death benefit level also gets the cash value that's been accumulated.
Yeah,
Um,
and that's a great example. Uh, Life insurance, it depends on, are you talking to the CPA, or you're talking to the estate planning attorney, or you're talking to the insurance agent, whether or not it's taxable or how you should protect it and things like that. I mean, it's different in every state, but this is where some of the confusion comes from. I mean, a lot of states have statutes where a creditor cannot take your life insurance. Okay. But we can also put a life insurance in what we call an ILIT, the irrevocable life insurance trust. Gives it more asset protection there because it's in an irrevocable trust. Two different concepts. One's protected by the state up to a certain amount. One's just protected by you because you set it up. But then you look at how these are taxed, and a lot of people will get you a life insurance policy because it is not taxed when you give it to the beneficiary. So when you die and it goes to the beneficiary, there's no income tax on that. However, on that same policy, if it's over the threshold for estate tax, there is a state tax owed on that life insurance. So if you have 20, $30 million in life insurance, some of it's going to go 40 cents on the dollar is going to go to pay estate taxes before your beneficiaries get it for the rest, for tax free. So it's really important to have kind of all the concepts together, all the team players together, so that you can look at these um, two opposite results and try to navigate between them to get the best of worlds for everything you can do.
I think that's a really key point because again, some of you listeners might be like, "Well, I don't have $20 million worth of net worth," but you could easily have $20 million worth of insurance, right? So, then upon your death, essentially that becomes your net worth. Whether even if it was a term policy, right? Because you could buy $20 million worth of term policy for and rent it for 10 or 15 years. And, but then that estate tax thing hits in because the $15 million exclusion excludes 15, but then you're paying 40 cents on the dollar beyond that. So this is a design and execute strategy. I think to answer the question, my version of that would be it seems like the practical thing would be first I gotta, like you always say, I gotta know what I have. What's my stuff? That's my estate, right? So what do I have? What am I trying to protect? What am I trying to pass down? I gotta do an inventory. As far as the asset protection side, kind of the lazy man, and I call it that. This is nobody else's language. It's just the lazy man's version of asset protection is I buy term or I buy whole life or some kind of policy against my run up, meaning like I'm not liquid yet for that amount, but I think I'm gonna be. And if I die in the process, I want my beneficiaries to at least have what they could have got if I didn't die. Right. So that's kind of like lazy man's asset protection. And if you don't have that, you should probably get some insurance. But that's not asset protection for sure. That's just like liquidity protection if you die before it's liquid enough to pass down. So some people might have insurance in place and they probably set it up with someone they don't even have their number anymore. Maybe they do. But then they don't have an estate plan. When they start to think about that estate plan, now they're planning for their incapacity or their death, which means the estate plan and the asset protection are dealing with two different time periods, right? Asset protection is dealing with now while you're alive. And
Right.
and then from your creditors when you're gone, whoever gets your stuff, like there could be asset protection that then lives on beyond you. But that's dealing with kind of protecting you against attacks while you're capacitated, while you're in capacity, and while you are alive. Whereas the estate plan is like, what's going to happen when you no longer are?
Or
So
you're
you could argue that first, figure out what you're going to do when you're not here and you're incapacitated, because that gives you the universe. Insurance is kind of like your hedge against something happening before you have those plans in place. So you should probably get something in place just to make sure people get something while you're figuring that estate plan out. Then your asset protection priorities get layered on. This is my practical approach. Once you've identified what you're going to pass on and to whom and how and through what vehicles and means, as you start to figure out that architecture, that's where you start to realize, you know what? I should probably put some of these active asset protection trusts in place or things like that for the assets I don't need today or for the rest of my life to live on, but that I want to be inherited. Because that's where you compartmentalize kind of the stuff that you own versus the stuff that's irrevocable that you don't own and maybe don't even control that your trustee does.
Yeah, yeah. So you're thinking about the time horizon a lot of times with insurance. When you're young and term insurance is really cheap, that's what you get. And it's if I pass, this will pay my debts, pay off the house so that my loved ones will get the house or whatever. But as if you're building trust or you're looking passing things down or you're looking to take care of yourself during your incapacity, then maybe cash value becomes more important. And now you need to look maybe at a different type of life insurance product that's going to help with those type of things where you can get some money to take care of you and things like that. Or you have something that you can pass down to the loved ones, even if you age out of the term or whatever. So it's this holistic approach at looking at how you want your life to go and how it's going to go. Right now to when you pass, when you become incapacitated, whatever we hope never happens, but that's the idea, and that's why I think the team approach is almost, mandatory because everyone looks at their little silo, the space where they work every day. They look at it a little differently, and they just give you a different lens, do it with a different lens to advise you.
Yeah, and everybody has their fees in mind, right? So, that's the other thing is understanding how they work together, and what that aggregated fee structure looks like, what it could be, what it should be, what it doesn't have to be. Um, and those are those. I think it starts with understanding what you're building and what you're going to hope lasts beyond your efforts, because no matter how long you've built it, at the end of the day, in order for it to last, somebody's got to understand where it is, what it is, who's in charge of what pieces, who's cleaning what corners and maintaining what corners. And that inherently, again, in my experience, means I probably want my counsel in that quarterback position helping me call the shots. Because even if we're not sure during that work product side, whatever we put in place or don't put in place, if it's executed through that person, becomes one less thing that is discoverable if I didn't do something to make it discoverable. So it gives me that privacy and that protection while I'm designing it, while I'm implementing it. And then I have the kind of comfort of knowing as we move down certain paths, what do we disclose or not? And is it worth it? Is that account really needed? Is that jurisdiction really necessary? Right.
Yeah, neutral party to help you, get through all that, I mean, if I'm only getting paid by assets under management, I may not think that any investment, even though I preach diversification, but I may think that any investment in something that doesn't have assets under management is a bad idea, even if that's returning 35, 40%. It's in a small business, another small business, and I don't get paid from that. So I'm going to say, no, you need to take that money and put it in the S&P or whatever, S&P 500. But that just those kind of things that you don't think about. I mean, you just need kind of a neutral party or someone who's willing to ask all the questions to see how you're going to build these things, not only from insurance, but from your portfolio, and the actual production. You really need to work alongside the client and all the professionals to tailor made solution.
So winding down, a couple questions here that we didn't touch on yet. Let me get to one that I okay. This one's on fraudulent transfer kind of time horizons. I've heard that I should move assets into a trust or a new entity before something goes wrong. How early is early enough? And what actions cross the line into potentially fraudulent transfer? So I think you're just wondering, like, obviously, if you think or know something's coming and it hasn't happened yet, but it's imminent, you could take the risk and move stuff now. But if it happens next week, it's going to look like you knew, right? So you're going to have to defend that. But assume that you don't know and you're just trying to go for that rainy day that you don't want to have happen, but that probabilistically could. What's the time horizon that is call it prudent, safe, ideal as far as preventing a risk of someone calling it fraudulent transfer?
Yeah, we call that the Uniform Fraudulent Transfer Act or the Uniform Voidable Transaction Act, which is the new name coming out, replacing these. And it's really state driven for how long it's going to be. Is it 4 years? Is it longer for bankruptcy? Is it 2 years? Is it 1 year? But there's this kind of marination period, if you will, that you have to have something set up and you have to have it funded for a certain amount of time to let the dust clear and make sure there wasn't any creditors that you were intentionally moving the money into a trust so you didn't have to pay them. We always say that it's best when you have nothing but blue skies on the horizon. Think anything's coming. And you start looking at it really closely, and that's like, well, I got a mortgage on my house for 30 years. If I
Right.
put off money in an asset protection trust, am I trying to defraud that mortgage person because I knew I did it? Get in there. So there's a lot of questions. There's a lot of things you really have to look state specific to see, how you're doing that. And then follow the rules. Sometimes if there's a lawsuit, that they're asking for, let's say, $200,000. You want to transfer $500,000 into a trust. Some states allow you to do an affidavit where you say, hey, I'm going to put 500,000 in this trust. I'm pretty sure 300,000 of it's clean, but I just want everyone to know that 200,000 of this has potentially been spoken for, that I'm willing to take out and pay if I need to. So, you basically have to follow the rules. And I think it comes back down to what we've been talking about today. As more and more people are funding others to sue you, they're coming up with their little rules and, what makes the jury bite, those kind of things. So you owe it to yourself to kind of play the rules on the other side so that you have this history, you have this length of time showing that you've been doing everything you're supposed to do before the event happens. So if I just had to give you one number, I'd say 4 years. But most of the asset protection states that have actually passed the rules have a lot shorter time period.
Yeah, and I think, part of it is too, somebody asked the question that I'll summarize here, around how do I, um, how do I do this properly but not create an unmanageable web of entities? I feel like I hear that a lot from folks who have a skeptical or a almost an uninformed understanding of what liability companies, limited liability companies, LP, like what companies actually do and don't provide, right? So they're like, I don't want to be, I don't want to have this web of companies because it looks weird or it's too costly to maintain all the minimum franchise tax fees or whatever it is, and my net worth or my assets doesn't, you know, enable it yet. But like anything else, you wouldn't put if you had a bunch of assets, you wouldn't put everybody in the same room. You wouldn't put everything in the same storage unit. You'd probably have a vault. You'd probably have a storage unit. You probably have that. If you have 5 kids, you don't put them all in the same bedroom, and live. Like, in other words, whatever the asset is, you probably have space between it and other assets just in the rest of your life. And if you think about it that way, it's a little bit less kind of overwhelming. And you go, okay, well, it makes sense. If I have intellectual property, trademarks, images, likeness, name, trade secrets, that should probably live in a separate container than my operating company that has W-2 employees and risk and liability and customers. Because if someone gets hurt there, well, they can sue me for what the assets of that entity are, but they don't need to have all my intellectual property because my intellectual property could be licensed to that entity from a separate entity for the exclusive rights to use it for whatever that business is doing. If you think about it that way, there's probably a couple of entities related to your operation. If you have real estate, you don't put all 100 properties or all 10 rental units in one LLC. Because if somebody breaks their hip in a shower at property A, you don't want them to sue you for all 9.
Right, right. Yeah.
Hmm.
If it's personal property, usually we look at personal property and business property. And, if you think about it that way, you got your business property at your business location. You don't have the copy machines and the desks and everything in your dining room. Likewise, you don't have your china and your dining room table in your business. You want your personal stuff and an entity that will hold personal property. And you want your business stuff in a entity that's for business. Intellectual property, that's more personal. I hold it as a person, not really as a business. I could hold it as a business, but that's a discussion that you have with your team to see if that makes sense. But you're just starting there. The personal assets need to go, more to something like a trust. Or the business assets need to go into something more like an LLC or a corporation or something like that, where you have more flexibility to run everything and you're not passing money in and out of a trust, getting permission to do all that. So a lot of it just starts with what type of asset. Uh, and is it going to be my house or is it going to be my business? And even with real estate, you're going to treat your house where you live probably a little different how you treat the real estate that is housing your business or the real estate that is, housing tenants and things like that. You should treat those different because one is a business type of structure and the other one is a personal structure.
Yeah, one of the questions came in as we wrap it up, and then I'm going to an 11 a.m. with Alexandra Damsker on a deep dive feature of her work. So if you're game, you can tune back in at 11. We'll be right here on Substack Live doing that. But wrapping up Matt Chats for this Wednesday with, a Another way to think about too, the asset slash liability of your employee headcount. One of the questions that came in was specific around, as I grow and my risk grows around number of people that work for me and things like that, how should I separate? We've talked about a lot in the past. You, it's not relevant for every business, but especially if you hire remotely or if you do that, you really need to look at your employee and your HR function and decide whether that really needs to live in your main operating co or whether that could be outsourced. Um, you've heard me talk about Pebble. It's who I use, PEBL. There's plenty of people out there. I recommend them because I use them. They're a subscriber. You can check out highpebble.ai if your understanding of HR and compliance and that kind of risk is based on, well, where I have employees, I also inherently have nexus. So if I have a Wyoming company or if I have a Texas company and I do that, but I hire Chris and he lives in California, technically, if I hire him as a W-2, I have just put nexus in a state that I probably moved away from. And so do you want to not hire Chris, or do you want to hire Chris but not have to be the employer of record? If you don't want to be the employer of record but benefit from the work product that Chris can put out, then you would use something like Pebble to do that because they're the employer of record and Chris technically works for them, but for your benefit. And so those kind of structures also are really worth looking at when you think about just your operating risk and and what is core to your business. Are you an HR company or are you selling sandwiches or auto parts or dental services? If you're selling something that isn't HR, you should probably not core your business in the HR function. And similarly, if you are managing your own wealth, but you're not an estate planning attorney or you're not an RIA, you should probably outsource that. I think the fees under administration or that are being watched over will start to grow. I could be wrong as the fees around growing those capital assets compress, right? We've seen 1%, from 2% management fees. We've seen 25 basis points on ETFs versus 50. So fees are compressing on growing my wealth. Billable hours are going away. And I think the fees under administration justifiably, hey, am I willing to spend 50 basis points a year or 100 basis points a year to protect what I've got? That starts to change the conversation when I think about having someone like you as the quarterback. So uh, that's our wrap up for today. Get in touch with Matt. If you're watching this on replay, you can ask more questions. We'll be back here next Wednesday and you can email us anytime. And human beings answer the phone over there. So feel free to call the numbers and we'll see you guys next time. Thanks, Matt. It's great to see you, buddy.
Thank you, Chris, as always.